Welcome to Litigation Nation. I'm your host, Jack Stanker, along with Danessa Watkins. As a reminder, this is the show where we recount the most important and interesting legal stories of the past couple of weeks. Danessa, what are we going to be talking about today?
A beverage giant was recently sued under Illinois' genetic privacy law. So we're going to discuss the allegations of that case, and we'll hear from one of our partners, John Ochoa, who has both litigated and published on the topics of privacy rights with regards to biometric and genetic data.
And we're going to be talking about a really interesting write-up in the New York Times on the newer legal standard that's being applied to certain constitutional challenges by the Supreme Court. It's the history and tradition standard that's being deployed first by the Supreme Court and now by some of the lower federal district courts, and what that might mean for some of the upcoming challenges on some landmark rules and regulations in the next couple of years here. All that and more, here's what you need to know.
All right, so Great Lakes Coca-Cola Distribution LLC and Reyes Holdings LLC, which is one of the largest food and beverage producers and distributors in the U.S., have been sued in Illinois state court for alleged violations of Illinois' Genetic Information Privacy Act. This class action was filed by a proposed group of job applicants claiming that their genetic privacy rights were violated when they were required to submit to physical exams and provide a family medical history as a condition of their employment. So just kind of in summary, and we'll get more into this during the show, but the Genetic Privacy Act bestows a right to privacy in a person's genetic information and a right to prevent the solicitation, collection, and disclosure of such information. So as alleged in this recently filed complaint, quote, genetic information, including familial health history, is a uniquely private and sensitive form of personal information. The genetic information contained therein reveals a trove of intimate information about that person's health, family, and innate characteristics. In requiring prospective employees, such as the plaintiff, to disclose their family medical histories, defendants have violated plaintiffs' and the other putative class members' statutory right to genetic privacy, end quote. So the lead plaintiff in this case, Antonio Penaloza, he applied for a job as a maintenance mechanic in Reyes facility in Niles, Illinois. And then as part of the application process, Penaloza was required to undergo a physical exam and answer questions regarding the manifestation of diseases or disorders in his family members. So, for example, whether he had any family members with a history of heart disease, diabetes, other medical conditions. Now, I know that I've seen, and I'm sure we've all seen these type of standard questions on medical forms. However, the issue here is that providing this information was part of the hiring process and a condition of the employment. So as alleged, Penaloza would not have even been considered for that job unless he disclosed this sensitive information about his family's genetic information. The class of plaintiffs here are individuals who had applied for employment with Reyes and similarly were required to disclose this private information and data in order to be hired. So in this case, the plaintiffs are seeking injunctive relief as well as the following, which is expressly provided for under the Genetic Privacy Act. Statutory damages of $15,000 for each reckless or intentional violation of the Act. Statutory damages of $2,500 for each negligent violation. And then reasonable attorney's fees, costs, and other litigation expenses. Generally speaking, I think we can all agree that the advancements in biological science and genetic mapping have had a significant beneficial impact on modern medicine. But there's also been a whole host of privacy issues that have attached to these technologies. And these debates on scientific advancement versus rights to privacy, they've been swirling for decades. So when I was doing a little research, I found that as early as 1996, the Center for Disease Control expressed concerns about people's rights to security and privacy in their genetic makeups. And then 2 years later, in 1998, is when the Illinois General Assembly enacted the Genetic Privacy Act. They recognized in part that people's genetic information could potentially be used as a source of discrimination. So Illinois was actually somewhat ahead of the game in passing this legislation. because it wasn't until 10 years later that Congress enacted the Genetic Information Non-Discrimination Act of 2008. So this was the federal framework for prohibiting discrimination on the basis of genetic information with respect to health insurance and employment. So, despite the fact that this law has been on the books in Illinois for 25 years, it wasn't until recently that plaintiffs began using the Genetic Privacy Act as a basis for their claims. So, to dive a little deeper into this subject, we're excited to have our partner, John Ochoa, on the show to help educate us more. John, thanks so much for joining us. Let us know a little bit about your practice here at Amundsen Davis.
Hi, Vanessa. Thanks for having me. So, I'm a member of the Cybersecurity and Data Privacy Service Group here at Amundsen Davis. In that capacity, I advise clients on best practices and legal requirements for privacy disclosures and help them with regulation and guidance regarding privacy and cybersecurity. We also help clients with data privacy laws, particularly those that govern data collection, storage, and sharing of sensitive private information. That includes biometric and genetic data. I'm also on the class action litigation team here, which litigates consumer and privacy class actions.
Excellent. So you are the perfect guest to talk about these crazy new cases under the Genetic Privacy Act. So let's jump right in. It seems like the floodgates are officially open here with these civil actions. Can you give us a little bit more background about the purpose of the Genetic Privacy Act and who or what it was intended to protect?
Sure. So, the Genetic Privacy Act is a fairly comprehensive statute. It's much longer than the Biometric Privacy Act. The statute regulates not just employers' actions, but also other industries, including the insurance industry. And the law has two main components. The first deals with the protection and sharing of one's genetic information. Basically, this means that if someone or some company collects your genetic information, they can't share it with anyone else without your written consent. The second portion of the statute is a non discrimination aspect, and that basically means that one's genetic information cannot be the basis of hiring or firing decisions, demotions, or other negative outcomes in the workplace. The statute has many requirements specific to employers.
Okay, and I'm sure it does, but of course, we wouldn't have jobs unless we litigated the terms of statute. But does the statute provide a fairly comprehensive explanation of what genetic information is?
It does, and the definition in the statute is fairly broad. The Genetic Privacy Act borrows the definition of genetic information from the federal HIPAA statute. And it defines genetic information as information pertaining to an individual's genetic tests, the genetic tests of family members of that individual, the manifestation of a disease or disorder in family members of such individual, or any request for receipt of genetic services or participation in clinical research, which includes genetic services, by the individual or any family member. So the definition has many subparts. It's quite broad. Specifically, the provision concerning the manifestation of disease or disorder in family members could potentially encompass a wide variety of information. And I heard you mention this when discussing the Reyes case earlier. For instance, if a sibling or parent suffered from heart disease or diabetes, this could potentially be considered genetic information under the statute. And I say potentially because the full scope of these definitions has not yet been litigated in Illinois courts. So we can't say with certainty right now whether that definition is what courts would adopt or whether these complaints have merit when they say that someone's information about a family member is being collected during the hiring process.
That makes sense. So is it seems like you're saying that this statute isn't, we haven't seen it be litigated that much until recently. Is that right?
That's right. The statute was passed in 1998, and Illinois was really on the cutting edge when it enacted the statute. But it sat dormant for over 20 years after it was passed, and we've only seen a wave of filing of these cases in the last 12 to 18 months or so.
Okay, so we probably haven't even really seen any appeals yet. It's still at the trial court level for the most part.
That's correct. There haven't been any cases that have been litigated through trial on the merits yet. There have been a few earlier cases involving the Genetic Privacy Act. Some of them were data breach cases involving Illinois healthcare companies. There was one case brought related to the asset purchase of a company that dealt with consumers' genetic information, but lawsuits like the Reyes case we're only seeing pop up recently.
What are the damages that the plaintiff's entitled to?
Sure, the damages under the Genetic Privacy Act are pretty high, and they're 2,500 per violation for negligent violations and $15,000 for intentional or willful violations. Plus, the plaintiff's counsel can collect their attorney's fees, plus be awarded injunctive relief.
That seems comparable to the Biometrics Act.
Yes, it is. They're actually a bit higher. Um, Under BIPA, the damages are 1,000 for negligent violations and 5,000 per intentional violation.
So in the Reyes case, then, I mean, obviously it just got filed, and they probably don't even know the size of the class yet. But let's say there were 100 class members. If there was a finding of reckless or intentional violation of the act by the employer, then that could be $15,000 per litigant.
That's right.
Wow, that's pretty steep.
It is. And, that's obviously the deterrent effect of the statute. That's why they enacted it in that way. And that's probably why Illinois enacted the biometric privacy law in that way, is to discourage these types of practices.
Yeah, so I know that you're certainly well versed in Illinois' Biometric Information Privacy Act, or BIPA, as we love to call it. Can you give us just a kind of a comparison of BIPA versus this Genetic Privacy Act? Like, are they similar, or I mean, we know the damages differ a little bit, but they seem to have kind of the same aim.
Yes, I mean they're similar in the sense that they're protecting information about individuals that wasn't always traditionally seen as protected under the law. And I think that is coming about because of the advances in technology that have now allowed people to have their biometrics recorded. You use your biometrics when you open up your phone, either a face scan or a fingerprint. And now in the last 10 years or so, employers are using thumbprints and handprints for punching in and punching out rather than using a time card. So the technology is catching up, and Illinois was sort of ahead of the pack when it came to passing laws protecting this type of information. I think genetic information is somewhat similar in that 20 years ago it was a very new emerging type of field. Now it's becoming more common, with services like 23andMe or Ancestry.com. People are getting more interested in, their genetic makeup, and, maybe becoming more comfortable in sharing that with other people. So, Illinois again saw the potential risks of that information falling into the wrong hands or being misused or stored improperly. And that's where I think the Genetic Privacy Act comes in.
Yeah, that makes sense, because even BIPA was passed, I believe, in 2008, but like the Genetic Privacy Act, it really sat dormant for a number of years before the plaintiffs' counsel started seeing, hey, maybe we can bring some claims under this.
Yeah, absolutely. I think the use of fingerprint scanners by employers for punching in and punching out largely drove BIPA into becoming the statute that it is, where companies are still being sued on a regular basis. It helps that the statute has a 5-year statute of limitations, so plaintiffs' attorneys and their clients can look back 5 years in the past to find violations. So even if a company had updated their disclosures and were doing things the right way for the past 3 years, they could still get hit with these BIPA lawsuits.
Is Do you know that is the statute of limitations the same for a Genetic Privacy Act?
That is not yet known. That's one of the many questions that will probably need to be answered by Illinois courts, and this is something that happened with the Biometric Privacy Act, and I see it happening with the Genetic Privacy Act also, is that there are a lot of unanswered questions about, for instance, what's the definition of genetic information? What is the statute of limitations? How high should damages be under the statute? All of the same questions that have now been answered for the Biometric Privacy Act will have to be answered for the Genetic Privacy Act also.
Got it. Yeah, I did see a couple of rulings came down last year under BIPA. The Northern District of Illinois found that the statutory damages under BIPA were discretionary rather than fixed in amount. And um, the Supreme Court, it looks like in a split decision, 4-3 in Cawthron versus White Castle system, they found that a claim under BIPA may accrue each time a private entity collects or discloses biometric identifiers, so that's like fingerprints or retina scans, without informed consent, as opposed to accruing only with the first collection of disclosure. So, in other words, if you have an employee that's using a fingerprint to clock in and out, over the course of a year, every single violation could be a fine of as much as $5,000. Is that right?
That's right, and the courts have kind of thrown a bone to plaintiffs' attorneys and defense on BIPA. On the one hand, every scan could be a violation, but on the other hand, damages are discretionary up to $1,000 or $5,000. So a jury in deciding damages could decide to award damages much lower than $1,000 per violation. We saw this somewhat play out in a case brought against Burlington Northern Santa Fe under BIPA, where they took the case to trial and lost, and the judge awarded approximately $220 million in damages. After the Illinois Supreme Court said the damages were discretionary, the judge in that case ordered a retrial on the issue of only damages, putting the issue in the question in the hands of the jury rather than the judge. Before that jury trial happened, the parties settled the case for much lower than $220 million. They settled the case for around $70 million, which came out to approximately $1,000 per class member, which coincidentally is what we're seeing a lot of these cases settling at now. So I think we can take that as a sign that somewhat of a win for the defense bar, that they're a little nervous that a jury may not decide to impose annihilating damages on a company for these sorts of violations.
Yeah, I mean, I'm sure that once these lawsuits started being filed, it probably came as a real shock to a number of employers. And I'm just curious, has there been any action by the legislature to try to maybe push back? I mean, these statutes were enacted early, maybe before the legislature even knew how they were going to be used. So has this flood of litigation caused them to pull back at all?
It has. There's a bill working its way through the Illinois legislature right now that would take the per violation damages away from the the Biometric Privacy Act, and instead only allow a plaintiff to recover damages for the first violation. So in the example we had of a employee clocking in and clocking out multiple times a day, only the first time that employee used the finger scanner would a violation accrue. And there couldn't be recovery of additional damages for subsequent scans. That law seems to have pretty broad support amongst the Democrats. Republicans oppose the bill, thinking it doesn't go far enough, and they want to see more of the protections of BIPA rolled back. But given the support on the Democratic side, I expect that the bill will pass. With one key question being whether or not the bill will have a retroactive effect for employers facing Biometric Privacy Act claims right now.
So do you expect that the Genetic Information Act and the lawsuits that are being filed under that are going to kind of follow this similar trajectory of we need to first figure out what is the scope of this act and what are the definitions, like you said, the statute of limitations, and then maybe once there's been enough rulings on those basic issues, perhaps the legislature will take another look at whether they've gone too far again.
I think it will. I think the first main question will be exactly what is genetic information, and because
Mm-hmm.
that definition could make a huge difference in whether these pre-employment screening cases have legs or not.
Mm-hmm.
Uh, if a court takes a broad definition that asking someone about their father's heart disease or diabetes is genetic information, um, that could potentially open the floodgates for many more of these types of claims. If, on the other hand, a court takes a narrower view and says that only diseases or disorders relating to someone's genetics is genetic information, well, that would dramatically narrow the amount of diseases or conditions that could be considered genetic information, and probably put an end to a lot of these lawsuits.
So I guess it's sort of a wait and see on how things develop over the next 12 to 18 months. Not that I want to provide this type of publicity, but this seems to be one of those attractive, niche areas for plaintiffs firms right now to jump on, especially with the liquidated damages and fee shifting.
Yeah, it does. It has all the same hallmarks that the Biometric Privacy Act does. It has large statutory damages. It has fee shifting, um, pretty broad definitions, and it has a lot of requirements that more than an average company would know about or even have on their radar right now. So I think it could catch a lot of companies unaware. And if the courts decide that it has a 4 or 5 year statute of limitations, that's a lot of exposure hanging out there.
I think maybe noting BIPA litigation, at least, it was the BIPA litigation that shut down Facebook's facial recognition program. And I know that they paid out a pretty significant settlement on that. The financial penalties that have been assessed under similar statutory schemes have been in the tens to hundreds of millions of dollars. So something like this has that potential for like a knockout type penalty.
The Facebook settlement, which many Illinois residents are probably aware of because they received a notice, put together a pot of money of $650 million approximately to pay out in claims for people whose facial recognition features were captured under Facebook's tagging process. And if a large Illinois employer who for years has been collecting information about their employees, health histories of their family members is dinged under the statute, we can see the same type of damages. Um, Thus far under the Biometric Privacy Act, only one company has decided to take it all the way through to trial to see what happens, and that's Burlington Northern. Most other companies, virtually all of them, will settle the case prior to getting to that point. So another interesting thing to watch for under the Genetic Privacy Act is once we see the first settlements coming down the pipeline, if we do, and if we do, what size are those settlements? How much are they settling per class member? Um, the Biometric Privacy Act was in flux for a little bit, but now it's kind of settled into this sort of $1,000 per class member band, and obviously there's some differences in cases that might change that number, but generally speaking, we're talking about $1,000. Since the damages under the Genetic Privacy Act are higher, perhaps those might be more like 2,000 or 3,000. Um, on the other side of it, the violations under the Genetic Privacy Act maybe won't have the same type of reoccurrence that they do under the Biometric Privacy Act. Going back again to an employee punching in and punching out using their fingerprint multiple times a day, the damages accrue very quickly. Under the Genetic Privacy Act, there may just be one instance, one application, one time that someone's biometric information is collected in violation of the statute. So that may also put a damper on the amount of damages awarded in a Genetic Privacy Act claim.
Yeah, and then Genetic Privacy Act, I certainly don't know the ins and outs of it like you do, but it seems to be a little bit more limited in that, as you started off with those kind of two buckets of where these claims fall into, one being sharing information without written consent, and then the other being discriminating against someone based on their genetic information. So, and you may not have the answer to this, but it would seem that if a company is simply asking questions on a questionnaire and doesn't share that information or doesn't base its hiring decisions on that information, maybe there won't be a violation.
Yeah, so I think BIPA and the Genetic Privacy Act, in some ways, the Genetic Privacy Act is narrower. In some ways, it's broader. So the Biometric Privacy Act is principally concerned with you can't collect someone's biometric data without first getting their written consent and having a policy in place for how long you're going to keep that information and when you will destroy it. So that's a threshold for anyone collecting genetic information. I'm sorry, biometric information. And the Genetic Privacy Act doesn't prohibit the collection of genetic information on its own. What it prohibits is requiring employees to provide genetic information as a condition of employment or the application process. So theoretically, someone could voluntarily provide that information so long as the employer made it clear that it wasn't a condition of employment. That being said, you're walking into a danger zone anytime you're dealing with that sort of thing in connection with employment decisions or hiring or firing or promotions, anything. So I would caution companies to be very careful when they're talking about something that could be considered genetic information in the hiring process.
Yeah, for now, just apply that term as broadly as possible to protect yourself seems to be the best way to proceed.
That's what I would do. And, not to give legal advice out here on the show, I think it's fine for an employer to find out whether or not an employee would be able to perform the tasks required for the job. So if the job was in a warehouse that required a lot of physical activity, physical, labor, it's fair for an employer to find out whether that person is able to, say lift heavy boxes or whether they might have a condition that would prevent them from doing so. But that's different from asking someone, you know, does your father have heart disease or hypertension, or because that gets to trying to predict maybe whether that employee in the future may or may not be able to perform those tasks, and that's where you start getting into trouble with genetic information.
Very excited to see what happens with the Genetic Privacy Act. We'll also keep an eye on BIPA and this bill that's with the legislature right now. Certainly appreciate your time and your insights. Just for our listeners, how can they get in touch with you if they have further questions or if they're facing issues with these acts that are still being, deciphered and litigated right now?
Thanks for having me, Danessa. It's you can find my profile on Amundsen Davis's website at amundsondavislaw.com. You can reach me via email at jochoa, that's OCHOA, at amundsondavislaw.com.
There's a really interesting opinion piece in the New York Times on the emerging legal test that's being utilized first by the Supreme Court and now by some of the lower courts to decide constitutional questions. The piece starts with a summary of a recent case in Texas from 2022, where a student LGBTQ advocacy group was planning to put on a drag show to raise money for suicide prevention. And the rules around this show were, in my opinion, somewhat reasonable. The kids under the age of 18 can only come if they were accompanied by an adult. For example, no unaccompanied minors could come. So basically, the same rules of like a rated R movie. But the university, West Texas A&M, banned the event from campus, calling it derisive, divisive, and demoralizing misogyny. The group sued, arguing that this was an unconstitutional viewpoint discrimination act under the First Amendment. And the piece goes on to note that the Supreme Court has historically protected speech on public university campuses. So this seemed like a relatively straightforward case and probably an easy win for the student organization. However, the case was assigned to a judge in Texas who has been at the heart of several constitutional rulings lately. And this is in the Northern District of Texas, by the way. And looking at his opinion, it begins by immediately jumping to and utilizing what's been deemed the history and tradition test. This test was formally adopted by the Supreme Court in the 2022 case, the Bruin case. This was the one of the gun regulation rulings that the Supreme Court handed down in 2022. The Supreme Court applied that same reasoning in the Dobbs case as well. It's the abortion case. When it found that abortion was, quote, not deeply rooted in the nation's history and tradition. And that fact, according to the court at least, was at least somewhat dispositive as to whether or not there was a right to abortion that had existed under Roe beforehand. So utilizing this history and tradition test, the judge in the Northern District, Texas wrote, quote, free speech jurisprudence only intermittently invokes the historical analysis applied to other amendments and clauses. He cites the Bruin case and a few others, explaining that the Establishment Clause jurisprudence looks to history for guidance. And then the court goes on, said historical analysis reveals a free speech ecosystem drastically different from the expressive conduct absolutism of the plaintiff's briefing, unquote. So the student group loses. Now, back to the Times piece, I'm going to quote from there. Quote, the flurry of history and tradition opinions prompted an uproar among liberal court watchers. What counted as historical or traditional? The open-ended nature of the term seemed to invite a freewheeling survey of 18th and 19th centuries. One commentator, Joseph Furskin, a law professor at the University of California, Los Angeles, tweeted that it's basically a fancy way of saying if men in power didn't recognize this right as fundamental in ye old times, we won't recognize it now, unquote. According to a law review article by a Yale law professor, Reva Siegel, the court was playing, quote, memory games. She asks, why does the conservative majority appeal to history and tradition in exactly those cases when it is changing the law? The Times piece notes this caused all sorts of confusion on the bench. Judge Carlton Reeves, an Obama appointee, pointed out that judges were simply not trained to sort through the competing interpretations of history. Quoting from Judge Reeves, quote, we are not experts in that what white, wealthy male property owners thought about firearm regulations in 1791. Now, on the flip side, this new standard gets rid of a lot of the originalism standards that conservative justices have been using since the 1980s, because it really no longer asks what the intention of the framers was at the time that the document was authored. Instead, it asks whether there was a history and tradition of a given right or privilege in the years since the document was written. Justice Amy Coney Barrett actually noted at one point that the history and tradition test encourages judges to hunt for historical sources, which she said is like looking over a crowd and picking out one of your friends from the crowd. So the piece goes on to argue against the ways the history and tradition test is utilized, specifically taking issues with how it was according to the author, but also according to the American Historical Association and the Organization of American Historians, used to cherry pick historical examples rather than accurately reflect the real history of the United States, at least in the Dobbs opinion. But I want to focus more on the judge's qualifications for determining whether there was history or tradition of a certain thing in the United States at a given point in time. And here's what I will hang my hat on. I do think that judges are bad historians. I think anytime you're reading a Supreme Court opinion and they're doing this kind of deep dive on, what was going on at a given time in American history, it's usually pretty bad analysis. And how do I know that? Because every decision that the Supreme Court makes based on history is usually met with universal groans from actual historians. There's always complaints about how they got it wrong one way or the other. And really, when you think about it, I think it takes quite a bit of hubris to declare yourself an expert um, in a field like this. I think a lot of people look at history as soft liberal arts, whatever. I don't really think that's fair. I think it is more like a hard science than people think. And I'll go on the record here saying that history is a hard science. For example, to know how things were at a given point in time, you do have to understand the language, geography, the politics, the economics, the religion, the customs that were prevalent at that time. You have to know where to find that data. You have to know how to evaluate the trustworthiness of that data. Often the data is in a different language, so you need to know how to read that, and so on and so on. Now, what I think is interesting is contrast this with the cases that judges often hear, maybe in products cases or intellectual property. I mean, a judge would never so flippantly declare in their opinion that they themselves are experts in, say, chemistry or mechanical engineering, something like that. In those scenarios, they're going to listen to expert testimony. When considering history, the input of actual historians, though, is almost never given the level of deference that like a STEM expert would be getting, and that's kind of what really bothers me about this new emphasis at both the Supreme Court and now in the federal district courts on the quote history and tradition test. Is there's really no fact finding element of the history and tradition test. Like, I don't know, imagine there's a bench trial about whether a certain molecule either was or was not radioactive, right? Well, the judge is not going to just sit there and listen to the lawyer's arguments, one way or the other, and take them at their word and then decide, this thing is radioactive. The judge is going to hear expert testimony on the facts and is going to rely on that. At the Supreme Court level, but even at the lower court levels, there's really nothing similar to that when it comes to historical examinations. The litigants make their arguments, which are meant to be persuasive and, of course, emphasize the good facts while minimizing the bad ones. And there are amicus briefs that are filed, but as I mentioned, they're kind of mostly ignored when they come from actual historians. Instead, the judges kind of take on this mindset of, well, I can just read the history books cited in the briefs myself and decide what happened in the 1870s on my own. And they really would never do that in any other context. So as the judges and the justices move more towards this independent historical analyses that they are going to be the ultimate arbiter of, I think the decisions are going to be getting further and further unmoored from actual historical reality, as I think mentioned in this piece in the New York Times that I'm looking at, but just broadly and in general. And if you don't want to take my word for it, take a look at some of the amicus briefs that are filed anytime something like this is before the Supreme Court, and you'll note the one-sidedness of any of the major associations of history professors or historians typically don't agree with whatever the majority opinion is.
Yeah, so I'll admit that I have not read up on this case in preparation for this show, but I have seen just a slew of First Amendment issues and freedom of expression issues coming out recently. Well, a lot of them on college campuses, actually, for different reasons. But it seems like, so this opinion was saying that drag shows as a category has not been historically viewed as a protected expression. Was that the ruling?
Yes, and that not every type of speech at the on college campus level is broadly protected, which has I think broadly been the interpretation of the law. That only the types of speech and expression that are quote rooted in our history and tradition are going to be protected under the First Amendment, which is a significant narrowing of what I understand to be the law with respect to like college speech and things like that.
Well, it's a scary narrowing because it sounds like a stifling of ideas. I mean, especially when you think about the broader purpose of college life, it's to discover and to learn and find yourself and immerse yourself in other ideas and cultures. And so if we start saying, well, historically, this hasn't been protected, aren't we silencing, various levels of expression and speech? I'm hoping they take a close look at this at the appellate level. It seems like there just seems to be this push in a bunch of different avenues and circumstances to try to equate drag in general, drag shows, with some sort of like pornographic thing, as opposed to, I think the argument could be made that it could also be a form of like a playwright. Like you're putting on a performance, you're assuming a different entity or personality. I don't know why. Well, I guess I can understand why, but I don't agree with the shift to try and push it towards this explicit area. That, yes, of course there are restrictions under the First Amendment when it comes to obscenities and time, place restrictions and content. We limit content based on children and the age of the audience. But I just this seems like just another push to try to put drag into this category that I would argue it's not, or it's certainly not in every circumstance. So it definitely seems over inclusive. I did read a quick article that just said, and I don't know if it was the judge that made this statement, but I think it might have been that it wasn't so much who the people were. So I think he said if it was the Christian society that were putting on a drag show, the result would be the same. So he was trying to make it seem like he's not upholding this ban based on the fact that I think it was LGBTQ community that put it on. But I don't think that matters either way. Whoever's putting it on, it is an expression, in my expert opinion. And I also don't think that this isn't at a elementary school. So you're taking care of that aspect of the potential issues with obscenity. But again, I think it's wrong to label this categorically as an obscenity. And I wonder if those arguments were made. Let's keep an eye on this. I'm certainly interested to see how this plays out. But yeah, thanks for bringing it to our attention, Jack. All right, well, that's our show for today. Thank you again to John Ochoa. If any of our listeners have follow-up inquiries on BIPA or the Genetic Privacy Act, please reach out to him. As always, leave us comments, your thoughts on the show, topics you want us to cover, and we'll see you next time.